Welcome to Decoding IP. My name is Intrigue. We're here to talk about intellectual property and technology legal issues making headlines in plain English. We want to help you understand legal issues making headlines in plain English. We want to help you understand legal issues making headlines. We want to help. No.
My phone. Should I just turn it off?
Yes. All right, we're back. Thanks for getting through our technical difficulty. Isn't live streaming grand? All right, we're back. Thanks for getting through our technical difficulty. Isn't live streaming grand? All right, we're back. Let's try it again. Testing, testing. Testing. Yes, it's gone. Okay. There we go. Okay. Now we've got the echo taken care of, and it was the Facebook page. See what happens when you try to interact on live stream? It comes back to haunt you. So anyway, thanks for hanging out there and waiting while we got through the technical issues. My name is Antigone. Welcome to our Decoding IP discussion this week. We talk about intellectual property issues and technology law issues that are making headlines on the show. We try to talk about them in plain English so normal people understand what we're talking about. And, our goal really is to help you understand how these IP and technology law issues can impact your life and your business. Ultimately, our goal is to help you find, protect, and grow your content and creation. So thanks again for joining us. With me is Candace Kustenis, my colleague at Protorae Law and part of the Decoding IP team. Hi, Candace.
Hi, good afternoon. And I'm joining you from the beautiful historic Jefferson Hotel in Richmond, Virginia. So if there are any further technical difficulties, because of me.
Thanks for taking it.
I'm down in Richmond on business and wouldn't want to miss the opportunity to talk about Brexit.
Yeah, and I hope it's not lost on our listeners that actually right now the general election is going on in the UK, and it's a really big deal because there might be a transfer of power, and all of this is associated with an effort to try to undertake a realignment before the serious negotiation efforts start occurring with respect to Brexit and all of the thorny issues that the United Kingdom needs to get through as it exits the EU. So with that in mind, we thought it would be perfect to talk about the impact on intellectual property that this whole Brexit referendum will have, because it's a really big deal. They've been in the EU since the early 1970s, and it's going to be a real challenge to get out and think through all of the issues. So we're here today to tackle IP. We're going to focus on trademarks, designs, and patents, because those are the major areas that are affected by Brexit. And so Candace, maybe we should go ahead and start by talking about the current trademark and design regimes, and then we'll talk about Brexit and how it affects those regimes.
Sure. So currently there are several regimes in place, even while the UK is a member of the EU, and throughout the European Union. There are both what we call the national regime when it comes to trademarks, and then there is the EU regime with respect to trademarks. And I'll talk about the registered designs, which are fairly similar. But I'll start with trademarks. And in fact, because most business owners are more likely to own a pretty large portfolio of trademarks than registered designs at this point. So even if you're going to start focusing, the trademarks might be a good place to start. So right now there are two systems. One can still file in each individual country for a trademark. So one can today still obtain a UK trademark. Similarly, you can get a German trademark, a French trademark. But what the European Union has done is they've also provided a second trademark regime where one can file a single registration and obtain what's called an EU trademark. We used to refer to them as community trademarks. The nomenclature has changed. Now we say EU trademark, but it's still the same thing. It's a single trademark filing that we apply for and obtain a registration for a trademark that applies to all member countries of the EU, even as that may expand. It's meant to apply to all member countries. And so that's where we are today. And well, there's a third, I neglected to mention, there's something called the Madrid Protocol, which is a procedure that allows members who've joined this Madrid agreement to file one document within one country and then check off other countries where they want to apply. It's a streamlined procedure, but what happens is it still ultimately goes to each of the countries you've identified under the national regime. So in terms of the substance, we've got the two. You've got the individual country trademarks and you've got the EU trademark. So obviously what's going to be impacted is your stable of European Union trademarks. And the question becomes, once we have the exit date, how are you going to protect your UK rights if they can no longer be protected by your EU trademark?
So Candace, that's really interesting. Let's talk about registered designs now and what Brexit. Well, first let's back up. What are registered designs? Because I think that that's a concept that's strange to people when they think about intellectual property protection.
Registered designs, it's an industrial design. It can be product design. It can be packaging design. It's in the United States, sometimes we call them design patents. It's essentially when you're trying to protect the ornamental aspects of an article of manufacture, whatever that may be. But very common, it's going to be, shoe manufacturers are going to have registered designs, handbag manufacturers, some clothing designers. If you've got a particular bottle design or package design that is unique and ornamental in some way, a registered design is one way to protect it within the EU. They've got what's called, again, the EU regime for registered for designs is something called a registered community design. Similarly, there are still individual country design protections. So the UK does have still its own registered design. So like the trademarks, one can at this point still obtain both UK protection, solely within the UK for both trademark and registered design, but also there is the EU registration. And, not surprisingly, if a business is, operating within the European Union, throughout the Union, many companies have taken advantage of these EU regimes to get the single filing for both the registered designs and the trademarks. And that's what's going to be impacted. They may still very well have UK protection, and that's great. They can cut it off the list.
So moving on to patent enforcement, or I'm sorry, patent protection. So I wanted to talk a little bit about the situation with patents and break it into two pieces, which is the way in which you get a patent, because there's three basic methods, and then enforcement, which is another issue entirely. So starting with protection, there's the national UK regime, where you can just file in the UK Patent Office and get your national patent application. Convention. Then there's something called a European Patent Convention filing. And this is a centralized filing process where you can have the European Patent Office take a look at your patent application, decide whether it's worthy of actually granting a patent. And then after that, there are a number of steps that you have to take to what's called perfecting that filing and actually getting an enforceable patent in each of the countries that subscribe to the patent convention. And obviously it includes paying money, right? So there's other things you have to do, but it's a way to do what I'll call a one-stop shopping to try to get a patent that will cover you in most of Europe. And by the way, under the European Patent Convention, there are 38 contracting states. So this is really important because this is outside of the EU framework. It includes more than just the member countries of the EU. And that's going to become important when we talk about what Brexit does with respect to the UK and its relationship with this process. So again, it's not part of EU patent law. Now, there is certain guidance on claim interpretation here. There's one standard for patentability. And that's nice, it's harmonized. So people like using that route when they're trying to gain coverage, patent coverage in a number of different EU countries. Let me then go to the Paris Convention. The Paris Convention is the third option that I mentioned. The Paris Convention is what I'll call a streamlined priority process. And by that, I mean, if you have a patent application that you file in one of 177 different countries that have signed on to the Paris Convention, what happens is you get the priority date of your earliest filing under this convention in any subsequent country that you designate. So as Candace mentioned with the Madrid Protocol, this is a very similar procedure where you do your first filing and then you check the box on all the other countries where you think you're going to want to continue to move forward through the prosecution process. But it's not one-stop shopping like the European patent situation. There's not one centralized location that does all of the heavy lifting with respect to analyzing your application and deciding whether it becomes a patent. So that's the Paris Convention. So the interesting thing about all of those three methods when it comes to Brexit is there really is little to no effect on the ability to get a patent, right? Brexit doesn't have a significant effect there. But now we come to enforcement. So first I'm going to start with the current patent enforcement system. There are a variety of problems when you're trying to enforce a patent or several patents in Europe. And lost my light there. And one of the issues is in order to enforce your intellectual property protection across Europe, you actually need to file your litigation in Germany, file in France, file in any of these other jurisdictions where you want to actually enforce the patent. So you have to deal with parallel litigations, which can be expensive. They can lead to different outcomes, litigations. Each of these countries have their own flavor of law when it comes to infringement and to whether you can get an injunction and keep another party who's deemed to have infringed the patent from actually continuing to practice it. So you can imagine it becomes quite expensive and complicated for a party that actually wants to do something with their patent. So in recognition of that issue, for over 17 years, a variety of entities under the EU, actually 25 different countries, have been working on what's called a unitary patent and the Unified Patent Court. So this is the one-stop shopping from an enforcement perspective. And finally, before Brexit, they came to an agreement about having a centralized set of courts that would deal with enforcement for all 25 member countries. So if you wanted to sue somebody for patent infringement in one of those 25 countries, you would go to this centralized court system where there were a number of courts of what's called courts of first impression in various places within those 25 member countries. And whatever decision that court comes to is enforceable across all 24 countries. So obviously this is highly desirable for parties to have a decision one way or the other that affects rights across Europe. It's much less expensive, it avoids the forum shopping, and so that's why we're working very hard on this potential option. So we got to a deal, and then Brexit comes. And so in a minute, after we talk a little more about Brexit and what it means from a general legal perspective, we'll get into how we might navigate through this issue with the unitary patent and the UPC system at that point. So Candace, let's talk a little more about what happened with Brexit and why we're talking about Brexit and IP. So just to make sure everybody's on the same page, you probably heard a lot about Brexit, but don't really understand exactly what happened. Remember in the 1950s, the European Economic Community was created. And as I already mentioned, in the 1970s, the UK joined that community. In 2009, that was the first time that the group actually created a mechanism for a party to leave the community. And as you can imagine, the financial crisis had a lot to do with that. There were some very strained economies that were causing real problems for the other EU member countries. So they created a series of levers and systems for a party to leave. Now, June 23rd, 2016, that date is in my mind forever. That was the Brexit referendum. And it was a huge surprise to many, many, many people, including David Cameron, who used it as a tool to negotiate internally with. So it was a big surprise that the UK decided by majority referendum vote that they were going to leave the EU. And so after a lot of wrangling, they decided that they were going to go forward with this. Parliament would approve it. And they, in March of this year, on March 29th, they gave formal notice to their colleagues that they were actually going to leave. So what that means is that started a 2-year process in which they have to renegotiate the terms of their withdrawal with the rest of the EU members that remain and the terms of the new relationship going forward. So as you can imagine, there's a lot of work involved with that. And by some accounts, there's over 80,000 pages of laws that governed the EU member relationship. They have to consider all of that in figuring out what their relationship is with the rest of you going forward, and also what their own internal laws are going to be now that they're no longer governed primarily by EU law.
Yeah, I had heard just EU regulations alone, there are over 12,000. So there's a lot to get through.
So for us in the United States, it's like throwing away our whole system and starting over. That's a big task.
Yeah. Well, which is essentially what they've decided to do with the Great Repeal Bill.
Right. So Candace, talk a little bit about the repeal bill.
So should we? Are we?
What that means.
Yeah. Well, after so the very next day, the UK government issued a white paper talking about how they were going to go about this process. And first step is what they're calling the Great Repeal Bill. And under that law, what the UK intends to do is, upon the exit date, all of the regulations that were put in place back in the early 70s to implement and make EU law supreme will be repealed. So on that exit date, all of anything that was implemented to make EU the supreme law of the land will be repealed. During this 2-year negotiation process, what the government will be doing is taking a look then and I'm sorry, and at the same time, taking all of the EU law, both regulations and directives, and basically implementing it in the UK. So basically converting current EU law into UK domestic law, and then taking a look and making changes and revisions and repealing as needed to make the EU law make sense in the single UK jurisdiction context. So they're basically starting out on a level playing field in their negotiations with the EU, saying, we're starting off at parity. Our laws, our domestic UK law are the same as EU law, and then the negotiations can begin from there. So, and what they intend to do, and they're hoping, the hope is that within that 2-year period, the UK government will be able to work out enough of the questions as to how to make formerly, EU law make sense in a single UK context, so that on the exit date, things will can start right at the gate with the new law implemented and ready to go in a way that makes sense strictly for the UK.
Right. So that brings us to the question of the real impact of Brexit on trademarks. So if we move forward and say, okay, now that we are where we are and we've implemented the EU law as the default into our own domestic law, there's going to be some cleanup, obviously. What are the issues that we're going to see from a trademark perspective that they will need to deal with over the next 2-year period?
Right. Well, what will have to be determined is what, if anything, to do with the with EU trademarks. So, an EU trademark is, a separately existing registration, as if it were a French registration or a Italian registration. And the question becomes, what, if any, rights do we allow that registration to provide in the UK? So whereas this is a registration that pre-exit covered our UK jurisdiction, it would allow that registration owner to have rights within the UK. The question going forward is, what do we do with that registration? Do we say it no longer applies? You have no rights whatsoever if you are carrying an EU trademark. Does the UK government say, well, we will allow the EU trademark to cover the UK through our own legislation? So in effect, it hasn't really changed. Your EU trademark will still give you rights within the UK. Or do we come up with a mechanism by which that EU trademark can be converted into a UK trademark? So those are the questions that the UK government will have to walk through and determine what are they going to do with the EU trademark and how it affects and applies and provides rights in the UK jurisdiction.
So what about registered designs? What effect does Brexit have on the registered design system that's currently in force?
Well, they'll have to undergo a very similar process, because again, you have a registration that affects a particular design throughout the EU member countries. Now that the UK is no longer one of those member countries, what, if any, effect will we give to a registered community design in terms of protecting within the UK? And so, there are options to say either, we'll give it no effect at all. So, you're on your own. If you don't have your separate UK protection in place, do what you have to do. Or we will give it effect, even though we are no longer a member. We will implement our own legislation to say that this registered community design will give you protection rights within the UK, or will we give you a mechanism to convert it so that then, you will have a separate UK registered design, but allowing you to take advantage of your prior application date and those sorts of things. Those are all questions that will be considered in coming up with the new legislation for the UK Intellectual Property Office.
So that brings us to patents and a situation involving patents now that we have Brexit in the works. So as I already mentioned, it's not really an issue when it comes to actually getting your patent in Europe. It's becoming an issue with respect to the enforcement mechanisms and the effort to centralize and create a one-stop shopping situation if you want to enforce an European Patent Office patent within the borders of Europe, rather than filing individual litigations in different countries or choosing one country over another for a variety of reasons. So as I mentioned, the unitary patent and UPC system the whole process had been finalized. They had worked out all the details. All the stakeholders came to the table and said, okay, here's our ratification process. 13 of the 25 countries that signed on to this system within Europe have to sign. They have to bring it back to their own country through their legislature or whatever is appropriate in their particular situation and get sign off so that this has the force of law within their country. Now, as part of that ratification process, it can't just be any 13. It has to also include the top 3 countries that hold the most patents as of, or issue the most patents as of 2012. And that happened to include, dun, 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 the UK. So that happens. They're going through the ratification process. A number of countries have already ratified, and then the Brexit referendum happens. And so the question is, okay, this whole process, putting their blood, sweat, and tears into it for over 17 years, they've now come up with a process, including the process by which it becomes the law in all these countries. And the UK has to sign on. But the UK has just decided it's going to leave the EU, and this is an EU-driven system. So this is part of what they have to negotiate their exit from. So this is a pretty sticky situation. Now, the UK can actually block implementation of the system for a period of time. So originally, many people thought before Brexit that it was going to be in effect and actually become an active enforcement system early this year. So obviously that did not happen. Now the question is, what will the UK do and what will the other member countries do in order to work this issue out? The UK could be a holdup. They could just decide not to sign for 2 years. And then after that 2-year period, assuming there's no extension of the time period to negotiate by unanimous decision amongst the members, then they will exit, and then the rest of them can go through the referendum process going forward. Or they could become a member, continue their activity, and at some point they're going to leave 2 years down the road. So it's a real interesting issue because everybody, of course, would like to see the system go into effect, but they're going to have an issue with doing so without trying to work through this ratification issue. So Candace, what do people do when they're trying to figure out, before that 2-year period runs, while everything is uncertain in the IP space, how do they figure out what they should be doing? Right? What do businesses do now while all of this is up in the air?
Right. And I think that's the important takeaway because, 2 years, it sounds like a long time now, but as we all know, that's going to be here and over before we know it. And so even though there's a lot of uncertainty, clearly, what business owners can be doing now is their preparation. And I think that starts, at least on the trademark and registered design side, and even on the agreement side, I think that starts with inventory. right? So you need to sit down and understand what rights you have that are these EU derived rights, because those are the ones that are going to be affected. So first things first is just make a list and take an inventory and understand what you have that's potentially going to be affected, whatever the ultimate rules end up becoming. So that when we begin to understand what those rules are going to be, you can take action. And of course, it all comes back to budget. You can also have an understanding and an inventory of what rights are potentially affected at this point, and start, determining, are you going to need additional human resources to convert or do whatever you're going to have to do with these EU rights, what kind of budgeting, those sorts of things, to get your preparations in place so that you're ready to go once we understand what some of this implementing legislation is, has in store. So I think that's the first place to start. And once you understand what rights you have that are covered by an EU trademark registration, for example, it's then, okay, if this no longer affects the UK, am I doing business in the UK? I mean, do I care that the EU trademark is potentially no longer going to have any effect in the UK? Maybe you're not in that market, so it may not matter. But where is it going to matter? And then start prioritizing based on which trademarks, which registered designs, if you require continued UK protection, and you only have the EU derived IP registration at this point, know that those are ones that you're going to have to budget and start, and you'll have to make arrangements to get the UK protection, whether that involves applying for the separate right or again, whatever the implementing legislation from the UK happens to be, but you'll have an understanding of what you need to do when that time comes. Similarly, I think looking at agreements, but I don't know if you want to talk about patents before we get into that.
Well, we can talk about both of them, I think, at the same time. So with agreements, whether it's patents, trademarks, copyrights, or trade secrets, or any other IP for that matter, as you and I have discussed many times, reviewing those agreements is really critical when they involve activities or licensing in the EU. So for instance, many agreements have a definition of the territory or the IP that's the subject of the agreement. It might be attached as a schedule. For many, many years, we thought the EU included the UK, but in about 2 years, that's not going to be the case. So what that effectively means is parties negotiating having one vision of what the agreement would cover, and the agreement in 2 years is going to cover something very different. So this is the time to get your ducks in a row and start looking at your agreements and understanding the impact of this decision by the UK and the effect it might have on your company. Now, this can actually be an opportunity for companies. So there have been lots of discussions about the headaches associated with Brexit. I think that this can actually have a silver lining for businesses. Number one, it gives them an excuse to go back and clean up their contracts, right? So those old contracts that you wish you didn't enter into or had different terms, there's a reasonable basis to go back to the other party and say, look, things have changed, and the original territory that we covered in this agreement is about to change drastically. So we need to look at this again. And hey, while we're at it, let's look at the entire situation. So perhaps somebody hasn't been performing as you expected, or the product that has been delivered is not what you wanted. So it can actually be an opportunity to renegotiate or terminate if appropriate, because some material terms could have changed in the agreement because of Brexit and the UK's decision to exit the EU. There are, in addition to territory, there are some other provisions that I think are very likely to be affected. Those can include what we call choice of law provisions, which talk about which legal regime applies. Again, if it's an EU-wide situation, they might have the centralized EU court law applying to that agreement. Now, obviously, if you're a UK-based company and you're only doing business in the UK, for example, it may no longer make sense to have that as the governing law going forward. So there are lots of things like that. And also venue is another one. Where can somebody sue or require mediation or arbitration if a dispute arises? Those venue provisions may be governed, again, by EU law or reference an EU framework that no longer is appropriate or applicable to that party situation. So, Candace, you wanted to talk about patents. So, the whole thing with the centralized enforcement effort, this creates an interesting situation for UK-based advocates who are authorized to practice at the European Patent Office and actually prosecute patents. One big question here is, assuming that this centralized enforcement system and the unitary patent goes forward, will there be a negotiation that allows those advocates to actually participate in those enforcement proceedings, right? And if that doesn't happen, it will be a very strange situation because they will be entitled to represent a party who is undertaking the effort to get a European Patent Office patent and perfect that patent into a national phase filing. But when it comes to actually enforcing their client's intellectual property, one area where they might be hit is they can't actually participate in that enforcement process because they're no longer advocates in a country that is part of the EU. So again, that's one of those strange little issues that they're going to have to figure out going forward as they get into the details of the exit negotiation and think about how they tweak the unitary patent and the UPC system now that Britain has made this decision.
Yep. And then the other thing I was going to point out, of course, in terms of what can we be doing now or what should we be doing now? Of course, there's the, take an inventory of your registered rights to determine which ones are EU derived, and then determine if you still require UK protection, and then make sure that, you've got that set aside and you understand that it exists so you can take appropriate action. But also, what do we do going forward with new applications? And, I think even though it's going to result in duplicate protection for a short period of time, I think given all the uncertainty, it makes sense for new applications, if you're going to be, if you want to have protection EU-wide as it stands today, including the UK, that means filing both under the national regime and getting a UK trademark application in addition to your EU trademark application, both trademark and registered design. So, there will be costs involved. There'll be some double protection, but that's going to make sure that you're covered no matter what on the exit date.
Yep. Well, so obviously there's a lot more we could talk about and get into more details about things to look out for. But I think that we've covered some of the high level issues that businesses need to understand now and be thinking about now so that they can be prepared as things move forward and some of these questions lead to answers. So thanks for joining us for this discussion about intellectual property issues and Brexit. You can follow us on Twitter at Decoding IP and check out our Decoding IP blog if you want more information about intellectual property and news making headlines and how they relate to each other. You can also contact us at Protorae Law. That's where we live during the day if you have any questions or want to chat further about any of these issues. Thanks again, and we'll talk to you again soon.
Thank you.